everyone. We are so glad that you were able to join us today for this special webinar on the J-1 Physician Recruitment Success Guide for Employers and Recruiters. My name is Dejana Farrar, and I'm a member of the marketing team at Wright, Constable and Skeen. Before we get things rolling, just some friendly Zoom reminders that I'm sure you're all familiar with. First, please remain muted during the presentation so that we can avoid any unwanted background noise. Jan has also asked if you're willing to please be on video so that we can see the lovely humans behind the screens. This presentation is being recorded and will be available on YouTube and podcast streaming services next week, in addition to the Wright Constable and Skeen website. You'll all receive an email with those links when they're available. Lastly, if you have a question, please go ahead and enter it in the chat box, or raise your mechanical hand using the reaction button at the bottom of your laptop, tablet, or phone. We'll address as many of these as we can at a Q&A session at the end. Disclaimer: this webinar is provided for informational purposes only and is not legal advice. Participation in this webinar does not create an attorney-client relationship between Wright Constable and Skeen and the participant. The general opinions expressed at or through this webinar are the opinions of the attorney and may not reflect the opinions of the firm or any individual attorney of the firm. I have the wonderful opportunity to work with Jan and her team as they tackle J-1 waiver physician issues. So let me take a moment to introduce our speaker. Jan Pederson has been a tireless advocate for J-1 physicians and their employers for over 30 years. She co-founded the International Medical Graduate Task Force in 1990 and was awarded their Lifetime Achievement Award for her incredible work on behalf of J-1 physicians. She is also a recipient of the most prestigious National Award for Excellence in the Advancement of Immigration Law, the Edith Lowenstein Award. Jan is active in bringing immigration issues to the White House, Congress, and the executive branch, resulting in many positive changes, as well as effectively representing thousands of physicians and their employers in their waiver cases. Remember to turn on your cameras for us to see your lovely faces. And without further ado, I present to you the wonderful Jan Pederson.
Oh, thank you for that kind introduction, DJ, and thank you to all the participants for attending today and taking time out of your busy schedules. We hope to provide you with useful information today in navigating the visa doctor world, which is ever more confusing. So when encountering a visa doctor, the first question an employer or a recruiter wants to know is whether or not a J-1 waiver is available if they are a J-1 physician. Again, I would like to invite you to put your questions in the chat box, and if we don't get to them today, we will answer them by email. Or you can email questions after the seminar to me at jan@wcslaw.com. Our seminar today is an overview, and certainly in an hour can't be comprehensive in that it summarizes what has gone on since about 1990 to the present. The J-1 waiver world is ever changing. So today we're going to take a quick deep dive into the waiver world to familiarize you with waiver options for positions you want to hire. Often there are many more options than you think there are. So to get an idea of who our wonderful attendees are this afternoon, can you indicate by raising your electronic hands the following? How many of you are employers of J-1 physicians? That means working for employers or employers. Okay, are we having problems with mechanical hands here? Because I see some of our lovely clients who I know are employers. Oh, there we go. There we go. Okay, great. How many are recruiters of physicians, either internal or external? Very good. We welcome all of you. In the world of J-1 visa doctors, you are going to navigate up to 6 different government agencies, state and federal. So it is always a good idea to partner with an experienced physician immigration attorney to do an immigration checkup, to see before you spend the money to bring someone to an interview, whether there are any immigration issues or, better yet, solutions nobody knew about. We provide this service to our wonderful clients. Just a bit about me for those of you who don't know me. I know many of you on the call today, and I welcome the State 30 people who are with us today. A special welcome to them. I have practiced immigration law in the Washington, D.C. area since about 1980. And I have specialized in the J-1 physician world since the late 1980s. I, along with two colleagues, sadly both of them are deceased now, to launch the first waiver program, which allowed J-1 physicians to stay in the United States if they abided by the 3-for-1 rule. That means if you agree to work 3 years in a medically underserved area, we will waive the requirement that you go home for 2. So in about 1989, I had the pleasure of working with the Appalachian Regional Commission to develop their program. Other than the Veterans Administration, which I don't think holds a lot of interest for our audience, they used to do a lot of waivers, in fact, up to 250 a year, but for many reasons are not terribly useful at the present time. So the ARC program was the first one on the map other than the VA. Then came the U.S. Department of Agriculture, waivers, and the program exploded. The U.S. Department of Agriculture would sponsor waivers for any area which had a population of 26,000 or less people. Then came the HUD program, and the HUD created their program to place doctors in inner city areas. So I had the pleasure of working with those agencies and developing their waiver programs to be most useful to employers and physicians. Sadly, the USDA and HUD waivers died a death after 9/11. I have yet to figure out what HUD and USDA waivers had to do with 9/11, but it looked more like they wanted to get out of the waiver business and saw that as some sort of excuse. Then came the program you mostly are all familiar with, which is known lovingly as the Conrad State 30 programs or the State 30 programs. It is named the Conrad State 30 program because the wonderful Senator Kent Conrad from North Dakota was instrumental and led the legislation which created the Conrad program in 1994. Then late to the game, but now the shining star of waivers is HHS, Department of Health and Human Services, and then the Delta Regional Authority programs. So we're going to be going through the different regulations and policies of those programs. And here we are. All right, so finding your most valuable players, MVP. Tips for building your winning team of immigration doctors. All right, so like many things to do with governments, there is an alphabet soup of acronyms which can get very confusing at times. So we will go through the acronyms one by one, the most important ones to remember. All right. The alphabet soup. Okay, visa doctors have come to be known, come in 2 flavors, J-1 physicians and H-1B physicians. They're so designated because that is the type of visa which they come to the United States to complete their residencies or fellowships. So about 90% of all incoming foreign medical graduates today come with J-1 visas. That carries with it, the doctors call it the 2-year albatross. So when you are given J-1 status, you then are obligated to return to your home country for 2 years unless they get a job with one of you and can get a J-1 waiver. So the important thing to remember there is a waiver waives only the requirement that the doctor return home for 2 years before obtaining most other types of visas that they would work on. So it's not a license to work. There's another step to that, and we'll get into that later. The other flavor, which about 10% of doctors come in on these days, is H-1B. That means they do their residency and or fellowship with an H-1B visa. The doctors like that because it doesn't have any 2-year home resident, no residence requirement, practically no work restrictions. There is a limit of 6 years in that status, and unless it's waived, which it possibly is. There's also another requirement that they have passed USMLE Step 3 in order to do their graduate medical training in H-1B status. So in the physician world, any J-1 physicians on the call, feel free to correct me at any time. I've talked to thousands of you and hundreds of employers and recruiters. So all this is a lifetime of having the pleasure and honor to interact with all of you. But feel free to disagree with me. So the J-1 physicians think that they came into America and got a Volkswagen, and the H-1B physicians think that they came in and got a Mercedes-Benz. All right, so the Rolls-Royce we'll talk about briefly later, and that's the O-1 visa for extraordinary ability. In reality, what we found is the J-1 physician and the H-1B physicians tend to basically end up in the same areas, not always, and they're not required to. So on with our alphabet soup. Okay, so we have 2 kinds of visas, and now we have two types of waivers. You have your state 30 waivers and your federal interested government agency waivers. So the state, every state of the United States, plus, I shouldn't say including DC and Puerto Rico because we aren't states, but plus the District of Columbia, Puerto Rico, Guam, Virgin Islands, and the Northern Mariana Islands are authorized to grant 30 J-1 waivers per year for physicians to work in medically underserved areas, or in what recruiters and employers love are flex locations. Every state has a different rules for allocating their scarce 30 slots and have different application cycles and criteria. Please feel free to put in the chat box any questions you may have about a particular state, and I will try to answer them. Now you say, what in the world is a flex slot? A flex slot only pertains to the state 30 program, not to federal waivers. So each state may award up to 10 of its annual 30 slots to the physicians to work in areas which are not medically underserved, but where they will, from a location where they will treat some patients who reside in medically underserved area. So a Flex 10 is a recruiting plus for all of you who have locations which are not medically underserved. So, and again, it's state by state how they allocate them, and it really varies wildly. Check with us and we'll be happy to discuss it with you. Okay, now we get to the federal. We call those federal interested government agency waivers. So the law says that any agency of the United States government may sponsor a physician for a waiver if they deem it to be in their interest. So you can imagine that we work all the time looking for new government agencies to sponsor waivers. As I said, the Delta Regional Authority was the most recent one to join the fold. We have actually talked a number of other government agencies to do waivers. If you all have any ideas, one year I came up with the idea that since virtually every rural area has a railroad running through it, there's a little known government agency called the Federal Railway Administration. And we were having serious discussions, and we were working out a program, and then the general counsel resigned, and that didn't go anywhere. So for now, here's what we have. But don't limit your imagination to what we have here. So we have the Appalachian Regional Commission. That is the one we said was the first one earlier. So with all federal government agencies, your recruiting bonuses, they're open year-round, unlimited in number, if you qualify. So late-breaking arrivals or recruits may be able to benefit. The Appalachian Regional Commission, and we have their website up there for you. Go to their website, they'll tell you which areas qualify. They will sponsor all medical specialties. They are paperwork heavy. They are a geographic area of the Appalachian region. And I know I'm supposed to say Appalachian. All right, so Appalachian region, which runs from the bottom counties of New York State into parts of all states running around the Appalachian Mountains down to, Georgia and Alabama. All right, so that works if it works. Their processing is lengthy there, and you will find frequent frustration at being requested to provide documents that weren't on a list. Next one, Delta Regional Authority. They are wonderful, delight to work with. Back to ARC for a moment. We will define the areas. There are two lists of medically underserved areas. Just think of them in two lists. HPSA areas, health professional shortage areas, and the other one, medically underserved areas, MUA, MUP. There are more MUAs and UPs than HPSA, so you as recruiters and employers prefer the bigger list. But ARC will only sponsor areas on your HPSA list. You can find out whether your proposed work location is in one or the other of the underserved areas by just Googling HPSA, HPSA find by address. That's FIND by address. We'll put that in the chat box. So ARC, HPSAs only. Delta Regional Authorities will sponsor both HPSA and MUA areas. In other words, all medically underserved waivers. They cover 200 areas in the Delta region, which starts at the southern counties of Illinois and runs down to the Gulf of Mexico through Mississippi, Missouri, probably Kentucky, Tennessee. And anyway, their website is dra.gov and they list their counties. So you want to check to see if your area is in the county as well as being underserved. Then the hero of the COVID war in the waiver world is the Department of Health and Human Services. After we attorneys and employer, everybody nagged them for years, why will you only accept waiver applications from a limited number of healthcare facilities? So in the wake of COVID, they said, okay, we are going to give you half of what you ultimately want. And that is that they will sponsor J-1 waivers for all healthcare facilities, work locations. We've come to use this strange word, healthcare facilities, work locations, with a HPSA shortage score of 7 or greater. Again, when you go to the HPSA find by address, it will tell you their HPSA score. However, their downside is that they will sponsor only HPSA areas, not the MUA areas, and they will sponsor only primary care physicians, and they include hospitalists as primary care. That last word, hospitalist, was the greatest boon ever to those of you who want to hire and recruit J-1 physicians, because anecdotally, it appears that the overwhelming majority of waivers in the United States today are filed for hospitalists. So this change, which happened in, I have to go back, COVID years here, I guess it would be in the spring of 2020, they opened up to the whole United States, as long as you have the shortage score of 7 or greater, primary care and hospitalists. One caveat there, I've listed the primary care specialties, and they will sponsor a physician for primary care if they've done a fellowship, but only if it's a 1-year fellowship and the physician can begin work within 365 days of finishing their primary care residency. So we see that a lot with physicians who have done 1-year residencies in geriatrics is probably the most common. So it is possible with the work around to get them to work by July 1st. Again, the person in charge of the HHS program is very helpful, very accessible, will answer questions immediately, and their waivers go very, very, very quickly. Up until this waiver cycle, they probably, if case was complete and approvable, approved them in a week and sent them on to the State Department. It's increased a bit this year, but they will be responsive generally to legitimate expedite requests. Okay, those are our 3 common federal. I didn't put the VA up there, but I did mention it. Now, those are the 2 baskets of waivers, state and federal IGA waivers, which require employer sponsorship and a number of other things. There are 2 other kinds of waivers that are becoming more common, and that is hardship and persecution waivers. They are an excellent alternative to federal IGA waivers or state 30 waivers in many instances, particularly in those instances where there are no waivers left for a particular year. So these 2 types of waivers, we're not going into in great detail, but the petition, self-petition, saying that it would be extreme hardship to go home for 2 years to an American citizen or permanent resident, spouse, or minor child. Persecution waiver is where they don't want to return home because they feel they will be persecuted on one of the grounds. Of course, those would be big these days for anybody from a war zone, physicians from Syria, how could I forget? Syria, Ukraine, many other areas, Venezuela. So hardship and persecution waiver are much the same. They have a different filing trajectory, and they do take a substantial period of time, also increased by COVID. I would say we tell the doctors to figure on 12 to 14 months if they're lucky. So there's a timing issue there, but they're great. If you can get them, they can pretty much work anywhere with the caveat that if they're going to work on an H-1B, the H-1B employer must be exempt from the annual cap, which we will discuss later. Okay, the H-1B visa. If you have a J-1, state 30, or federal interested government agency waiver, you're required to work for 3 years full-time for the waiver employer. And only, remember this, only in H-1B status. If you're lucky enough to come up with another status, that's good, but it doesn't fulfill the 3-year waiver employment requirement. Now, another recruiting bonus is our Canadians. We are seeing more and more Canadians requesting waivers. And that's great. And the recruiting bonus is that if you're in a location that is out of waivers, out of state 30 waivers, you can't qualify for a federal waiver, and there's nothing else around, then a Canadian citizen, and only Canadian citizens, may obtain H-1B status without a J-1 waiver. It's a very good workaround. All right, that's without a waiver. However, the employer must be cap exempt, which most of you are. Okay, here's our definitions. We've already gone over them. Next slide. All right, the current landscape. The demand for J-1 waivers has increased dramatically for many reasons, but the good news is that the supply of J-1 waivers has exploded, and that's credit to the HHS. So you may be recruiting only subspecialists. You say, what do I care about the HHS waivers? Well, why you care is that for every waiver that's filed with HHS for primary care, that is a state 30 waiver that's not being used up and can be used for your subspecialists. That's why recruiters of subspecialists care about the expansion of the HHS program. Okay, I would advise everybody, and you all already know this, well, maybe not all of you, because I don't know all of you, but I would probably love to know all of you. So recruit J-1 positions carefully, as trade-ins and transfers are expensive and uncertain. Please read that twice. Recruit J-1 positions carefully, as trade-ins and transfers are expensive and uncertain. Now, they are possible transfers from one waiver job to another, and we'll get into that in detail in a minute, but it causes everybody anxiety, stress, and expense. So try to make sure on the physician's part, they want to be in your community and you need them in their community and make them feel welcome. Okay, we've already said that. So the anecdotal evidence indicates that J-1 physicians stay longer than U.S. physicians in medically underserved community, much longer than the required 3 years very often. So when employers seem hesitant, saying, I don't want a J-1 physician, I had one 10 years ago and he left. And then I say, okay, so how long did he work there? Well, 5 years, and then he left, okay, which is much longer than your typical American physician works there. So I always tell the J-1 physicians that they should consider themselves ambassadors for J-1 visa doctors, and how they fit into a community and relate to the community, and the community relates to them, will have an impact. Perhaps their brother needs a waiver 2 years from now. Well, they don't want to leave a bad taste in the community and the employer's mouth. So they say, I don't want any more. And that's unfortunate, but if you have any reluctant employers, I'll be happy to talk to them. So yeah, choose carefully, and they will probably stay if they're made to feel welcome. All right, drafting MVP positions. If anybody can guess who the guy being hoisted in the air is, they get a free consultation. Okay, again, reminder, because I don't want to be repetitive, but I can tell you that I can have consultations with doctors day in and day out, and they don't know, don't believe that federal waivers are unlimited number and available year round. So in worst case scenario, it's the end of the year and you want a doctor the recruiting year or the end of their training program. Worst case scenario, they can go home and wait a few months until the waiver is complete. Okay, another draft source for you all is spouses of H-1Bs, usually physicians, but not always, in H-4 status can obtain work permission in H-4 status if they meet the other conditions. It's noted that many H-4 spouses may also be physicians. So you want to always check on what the spouse's concerns are. I know that many physicians are very reluctant to bring up a spouse at an interview. I'm not sure why, but we always want happy spouses. So the more an employer or recruiter says, you know, we're in a position to help, we'll try to help your spouse. Many spouses of H-1B physicians completed medical school in their home country, but have held back on completing a residency here while the H-1B gets squared away, or to raise children or whatever. So if you in your area, this is often pertinent in rural areas, can help the spouse of the H-1 find a residency program that will cement your relationship and cause you to be at the top of their list of employers. Okay, repeat again. Physicians who completed training in H-1B status do not need J-1 waivers. There are some odd out there exceptions, but they do not. Okay, the cost of your MVPs. All right, the filing fees. Who can pay and how much? All right, so some waiver programs charge a filing fee. We're not, you know, the best practice is for the employer to pay. I think that sends the wrong message for the physician to pay, even if it's legal. There's some question about whether it's legal. In certain parts of the country, there's actually a United States Court of Appeals decision that seems to say the employer must pay. Sample fees, I think these are current: Texas, $3,000, DRE, $3,000, Ohio, $3,571, and there are a number of other states that have them. The ARC did have a $3,000 fee, but they dropped it. So those are government filing fees. There's also an incidental initial fee of $120 that you pay to the Department of State, and when we take care of that filing for the clients, $120. H-1B fees are really annoyingly high, ridiculously high, in fact. The employers are legally required, without exception, to pay the legal fees. That means the attorney's fees and the U.S. government filing fees. Filing fees have become so high that it's embarrassing that they are often more than the lawyer's fees. So your filing fees for the H-1B can total up to $4,960 in filing fees. And that would include, that number includes a $2,500 fee, which is optional, and it can be paid by either the employer or the physician if the $2,500 premium processing fee is for the benefit of the foreign national. So that's up for discussion. The filing fees were raised a couple of years ago, the premium processing fee. So what the premium processing fee does for everybody is USCIS promises to render an adjudication within 15 business days of receiving a petition, or they have to give you your money back. Well, supervisors don't like it if officers have to give money back because they didn't do it in 15 days. Now, have no illusions that 15 days means they have to make an adjudication. It doesn't mean that they have to approve it. So what we believe happens is that if an officer gets behind in their premium processing cases at USCIS, they don't want to get back the fee, so they just issue a request for evidence, and that is annoying to everyone. And it stops your 15-day clock until they get the response to their request for evidence. Okay, legal fees. And use your secret weapon. Partner with an expert hands-on physician immigration attorney early in the process. So some of you are in institutions, perhaps hospitals, where the general counsel has been told that the J-1 waivers are their responsibility. Do your best. And then general counsel, if they don't have immigration experience, will be happy to offload the responsibility for the J-1 waiver and H-1B process. Okay, everybody wants to know about timelines. The clock is ticking. So interested government agency waivers, state 30 and federal, are filed by the employer as the moving party with the relevant government agency. All right, so that can take anywhere from a day to 6 months. It varies among states and agencies. So since COVID, a lot of it, the processing times have gone up. Once the agency, the IGA finishes with the waiver, they make a favorable recommendation to the Department of State. That is where we're having the serious nail-biting experience this year and last year. They have increased their processing times, and I would say it's actually up to 16 weeks now. All right, then they make the favorable recommendation generally to the USCIS, and their processing time is 2 to 6 weeks. The tip for you to know is that an employer can file the H-1B petition for the change of status from J-1 to H-1B once the Department of State makes a favorable recommendation to USCIS if the clock is ticking and you're running out of time. We recommend that you wait till an approval if you can, because filing it with just the Department of State recommendation can result in one of those beloved requests for evidence, which delay matters, but if you have to, you have to. And the Agencies are so backlogged this year with the explosion of requests that we are even facing something where we may have to file the H-1B petition before the Department of State makes its recommendation. So I've received calls for second opinions from some employers and physicians say, is that possible? That is possible, not a preferred procedure, but desperate times require desperate measures, I guess. All right, common requirements for federal waivers. Everybody with a state or federal waiver needs an employment contract for 40 hours per week of direct patient care for 3 years. Those words must be in the contracts. 40 hours per week of direct patient care for 3 years. The direct patient care is actually a late-breaking, rather, requirement imposed by the State Department. So things will be slowed down there if you don't have those words in the contract. Federal waivers, no non-compete clauses. They are prohibited. Federal IGA waivers, primary care and subspecialties permitted except for HHS. The ARC has an annoying liquidated damage penalty clause, which basically offends our beloved J-1 waiver doctors. What they say is if things don't work out between the employer and the employee and the contract is terminated prior to the 3-year waiver commitment being fulfilled, the physician owes the employer $250,000. The Delta Regional Authority also has that requirement, but permits waivers, and that is almost uniformly waived by the physician and the employer. That liquidated damages clauses, even the ARC contracts, are rarely enforced. However, the message it sends is if anything goes wrong, it's the fault of the doctor. That leaves a bad taste in the mouth of the doctors, as it should. And I think we know collectively among the Immigration Medical Graduate Task Force, there have probably been only 4 cases since 1990 where it's been sought to be enforced by an employer against an employee. So it actually has to be the employer enforcing it against the former employee. Okay, we're going to hasten here so we have time to address questions. How many questions in the chat box? Let's go to the chat box. Okay, again, state programs, 3 years of work, 40 hours direct patient care. The facility must be located in the HPSA MU area or flex slots. Federal waivers cannot use flex slots. They all must be either in a HPSA or an MUA area, depending on which program it is. Okay, flex slots are a great tool for employers and recruiters attempting to place physicians in areas which are not medically underserved. Just by the way, if you believe your area is medically underserved but hasn't received the designation, we work with a consulting company who has a lot of experience in getting areas designated, which the state hasn't been able to designate. Okay. Okay, is the state work 30 program in the state user-friendly to J-1 physician? It depends, and in turn your employers, of course, because most of the paperwork burden are documents required from the employer. Burdensome paperwork or filing fee, Alabama, New Jersey, Ohio, Pennsylvania, New Mexico, Texas has a $3,000 filing fee. Waiver spots filled very, very early in September for the following fiscal year. So if you need a doctor in July 2023, you will need to file the waiver application during usually it's a week or 2 weeks in September. Okay, the states which we love and are user-friendly and have slots all or most of the year. Oklahoma, although Oklahoma did fill up last year, Nevada, Oregon, North Carolina, South Carolina, Maine, Delaware, DC, never ever fills up. Usually use only 10 to 14 a year. So employers, and which is really a function of employers in DC not being comfortable with the program is the best I can say it. Kansas, Louisiana, and Nebraska. Okay, which waiver programs should be used? Advantages. If your employer wants a non-compete clause, then you have to look, you cannot have a federal waiver. However, many states permit them, so then you want to take a look at the state rules on non-competes. Physicians do not want liquidated damage clauses, and really employers don't either, as they're rarely enforced. State programs, of course, more flexibility in job locations, allowing HPSA, MUAs, and the flex being the big one. Okay, now you want to know, I mentioned the different areas of the waiver world which require H-1B cap exemption. Okay, who is exempt from the H-1B cap? All J-1 positions with interested government agency waivers. They take that waiver and put it in their pocket and carry it with them forever, provided they fulfill their 3-year waiver commitment. So 10 years from now, you can find a doctor who got a J-1 waiver 10 years ago, fulfilled the waiver, then he is cap exempt, and you may not be a cap exempt institution or employer, but you get that position as a cap exempt physician. Okay, the next is a big one, which is not really widely understood or used enough. So if the petition is filed by an institution of higher education, we all pretty much know what that is, but the second part is, or affiliated nonprofit entity, residency programs, for example. Okay, this is the other big one that needs to be utilized more to place doctors in areas where you need them. Nonprofit entities affiliated with an institution of higher education, which includes teaching hospitals, many community hospitals, and certified rural health clinics. So many of you are cap exempt through that. Now, the next one is also one for everybody to be aware of. It's called the by-at cap exemption, by-at. So a physician employed by a for-profit entity to work at an affiliate nonprofit entity. So that the big group there are going to be your hospitalists, where the hospitalist service is outsourced. The hospitalist employer is a for-profit entity. If the hospitalists are going to be working at an affiliated nonprofit hospital that qualifies, then that's your recruiting plus there. Okay, the next one, you're not going to encounter much H-1B workers who have been counted once toward the cap within the preceding 6 years. Every once in a while, you will find somebody in that category. Okay, the next one is beneficiaries of multiple H-1 petitions. That's a recruiting plus. If the employer really needs this physician, and you're really for profit, and you really can't come within, any of those exemptions, then you may want to consider multiple petition scenario. It's a little complex, and we probably only do a handful a year. It's for really high value physicians that the employer will do just about anything to get. Okay, the other thing to remember is if you run into an H-1B physician who did their training in H-1B status rather than J-1 status, they are usually almost always cap exempt while they're doing their residency, and they lose the cap, flies away and disappears, and they're no longer exempt once they're out of their program. So that's a consideration in recruiting. I'm going to go through the green card section very quickly. Virtually all physicians want one. Most obtained through employer sponsorship or a national interest petition. It's a recruiting plus to physicians more than anything. I want green card security, more than a big salary, more than a Rolls Royce, more than almost anything. So offering to commence the green card before they start work or as soon as they start work is a great recruiting asset for you. India and China, there are special considerations because they have at least, I'm saying this charitably, 20 years to wait for a green card. So processing them is a different road, and we'll be happy to go over that with you if you have one, a candidate. Okay, if the physician's married to an American citizen or permanent resident, then we don't need employment sponsorship generally. Now, physicians may obtain other non-immigrant visas without a waiver. The most common one would be O1, a physician of extraordinary ability. That can get your physician to work if the state is out of waivers. You just don't have a waiver and you want that physician. They just don't hand them out at the door of immigration, though. You have to prove extraordinary. And anecdotally, immigration is pretty generous. Or a J2 spouse may work as a J2 spouse while the J1 physician is in J1 status. F1 isn't very common and isn't very useful to you. So what you can't have is an HL or a green card without a waiver unless you're Canadian. All right. Hiring game plan. Possible snags we've already discussed. Non-compete clauses, liquidated damages clauses, work locations. If the employer hasn't recruited for the position within the last period of time. Now I put 6 months to a year there. That is highly negotiable. You don't have to put an ad in your local newspaper every day for 6 months to a year, but be aware of that requirement. We just had a snag with an employer who had not done the recruitment, but we will be okay. So just be aware that the state and federal programs have different recruiting requirements to demonstrate there are no U.S. physicians ready, willing, and available for the priority. Waiver application deadlines. Remember, federal waivers open year-round. Every state has a different protocol. Some are first come, first serve. Others have a particular application period, such as Kentucky, Kentucky, Illinois, and their waiver application period is in October. And whether your application gets there the 1st or the 31st, they're considered equally. So our favorite states in terms of the way they consider application are Delaware and South Carolina. Those are really great. Those of you who are recruiters want to direct your candidates that direction if you can. And the reason being is that both of those states allocate the slots early. So right now, if I'm an employer in South Carolina in a medically underserved area, or maybe not, depending, the employer can ask the state of South Carolina or the state of Delaware, if the job is in Delaware, to reserve a slot for me. And that is wonderful. So I could, as an employer, can reserve a slot in South Carolina under their program or Delaware under their program right now. And the wonderful thing about that is it helps you recruit because you can assure the physician that you have a slot reserved and the employer owns the slot, and it gives the employer plenty of time to recruit. They do have a deadline that they will extend if you haven't found somebody to take the job. We would encourage other states to adopt it because of the certainty it provides to both employers and the physicians. Okay, we've already gone over this slide. You all know to file it at the earliest possible moment, consistent with sound hiring practices. We don't want you or the doctors to go into desperation mode and sign anything. That can be, as you know, a recipe for disaster. Make sure there's a good fit. You want to ask about the family, children's schooling, spouse's need for employment. Ensure the site visit is for a few days. What we say is, it looks very strange to a doctor if he's flown in on a Friday night, visits the hospital and clinic which is closed on a Saturday and leaves Saturday night. We tell them that's a red flag. So allow a couple of days. I know that the doctors are really, really busy and will have a hard time, but it's in everybody's everybody's interest to do that. Develop a community integration plan. Be a welcome mat for the doctor. Make them feel important and valued to community, because certainly in rural areas, they're very valued. And remember, the physician is just about as anxious as you are about the job and the new community. So anything you can do to make them feel welcome and comfortable is great. We just have a few minutes left. So we're replaying our footage. Okay, we're gonna skip the case studies. You can read those. The PowerPoint is available to you. What I want to talk about for just a minute are extenuating circumstances recruit. Okay, so we don't encourage any of you to steal doctors who've already gotten a waiver from another employer. However, there are circumstances, fortunately not that common, where just the reemployment relationship just doesn't work out. And the doctor is not going to make it for 3 years for whatever reason. We always encourage the employers to facilitate the transfer if they can, because no one in fact wants an unhappy doctor running around. So you can transfer. So for example, if I'm an employer in California and I want to recruit a cardiologist, I have little chance of getting any non-primary care waivers in California. However, I get a call from a doctor in Kansas who said, I hate it here, I can't stand another day. Will you hire me? All right, well, it's more complicated than that, and you want to really be careful about documenting extenuating circumstances. That goes with your new H-1 petition for your new employee. Approval of the petition includes a implicit finding that extenuating circumstances exist. So that you want to we rather have come to specialize in this. It's a case-by-case analysis. So there are really no rules about extenuating circumstances unless a hospitalist company loses its hospital contract. That's okay. When the facility itself closes. Otherwise, it's based on anecdotal evidence and experience. So failure to pay the H-1B wage, that would be recognized. Those are some circumstances where you can be pretty sure. So basically, that's a delicate area, primarily because the circumstances which immigration will accept, and it is USCIS that makes that decision, not the State Department of Health, not the Department of State, but only the employer. Okay. We've given some examples: spouse or child develop an illness that can't be treated in the area of the waiver job. Usual employment law claims, it's like sexual harassment, discrimination, toxic work environment, etc. And I'm sure none of our employers here would ever have such a thing, but there are places where it apparently happen. It does happen, actually. We'll stay over a few minutes. Risky claims. Emotional harm of being separated from a spouse doing training outside the area, especially where the separation was known before the waiver was granted. Saying the job not a good fit. Well, that's pretty much always the case. I've seen denials of permission to transfer on that grounds. Claims about the standard of practice medicine, we tell doctors and everybody stay away from that. Resignations versus terminations. USCIS doesn't love resignations. A lot of waiver programs do not permit without cause resignations, which is often a problem that we work through. Workload heavier than what was promised during the job interview. Common complaint. In the aftermath of COVID, not much weight is going to be given to this by immigration. The transfer process is to only two things I would tell you: resist the temptation to premium process. The physician can generally start work in the transfer job as soon as the new employer files the transfer petition if all the requirements are met. Age for a spouse. These are case studies I want you to read over. They happen a lot. I'm going to try to finish up here. Short summary. We've gone over that. So that contact us if you have any questions. Now we're going to go to the questions that we received in the chat room. No, go to more. Okay, we've got 10 questions. If you all don't mind staying a few extra minutes, we have 3 minutes left in the hour. Let's start at the top. I'll get back to anybody I can't answer. Okay. Next question, does the start date on the H-1B petition matter? Yes, it matters a lot. Stop there, please. It matters a lot on the H-1B petition. There are a number of dates, but the latest date you can have is the start date on the petition. The initial waiver job petition is within 30 days of the program end date as listed on the Form DS 2019, which all J-1s have. Okay, so that does matter. We seem to go around and around on a lot of that. Must they start work on that date? No. Anyway, they can't start work until the H is approved. So the point is to keep the start date. If you list a start date more than 29, we use 29 days, but it's actually 30 days. So be careful about that date. If you use a date after that, the change of status will be denied and there'll be all kinds of problems. Next question. Is it accurate to say that an H-1B contract can have a non-compete, but a J-1 cannot, regardless of physician or dentist? Dentists we're not even talking about. They can do anything. You can have anything you want in the contract. It's valid under federal and state law. Immigration doesn't have a horse in that race. Non-compete fine for dentists, H-1B non-compete if it's a federal waiver, no non-compete if it's a state. It depends on the state. Next message. If a Canadian citizen completes his training on a J-1 visa, finds a non-waiver job on J-1B status, does he still have to complete a waiver in the future, or is he, can you scroll down, please? Or is he always exempt? That's a great question, thank you. The J-1 visa can work, the Canadian citizen can work on H-1B without a J-1 waiver. How indefinitely, basically, however, in order to get a green card, they have to get a waiver, eventually. Next question, please. When should we start the process and look for the waiver job? I mean, what year of the fellowship? Probably right now, if you're graduating in 2023, you should be actively looking for a job. So a year and a half, but don't rush, don't do foolish things, look around. There are plenty of waivers around depending on your field, but don't sign the first contract given to you. Next one. Great question. Next one, can direct patient care be done via 100% telehealth? That is on a case-by-case basis and depends on the agency. That's only been recently, of course, discussed in the waiver context about teleworking. And again, it depends on the agency. Next question. Is it optional for the employer to pay for the premium processing fee for H-1B? The employer or the foreign national physician either party can pay if the premium processing, the expedited process, is for the benefit, probably to a really stricken interpretation would be solely for the benefit of the foreign nationals, such as to get a driver's license or travel abroad or something like that. Next question, can the physician work at a different worksite location than the one on the labor condition application with the Department of Labor? Great question. So as part of the H-1B process, there's a labor condition application that gets filed, which must list all possible work locations, even on an emergency or fill-in basis. So first, the labor condition application must include all the required work sites that and authorized under the J-1 waiver. It may list additional work sites where they will fill in on an emergency or as needed basis, or where they will work once they complete their 40 hours in the authorized underserved areas generally. Next question. Is it important to maintain a public access folder for each H-1B position? Boy, is this questioner knowledgeable. Public access folder is required in connection with the H-1B petition, and it must be maintained by the employer in case the USCIS or the Department of Labor does a random audit and comes to visit you. And just a heads up, it happens rarely in the J-1 position, in the physician world. If any of you gets a call from somebody saying they want to stop by and interview you and the employee, call the lawyer immediately to make sure everything is in order for your audit. Very strange things have happened. Sometimes where you're employed by a physician is employed by a private practice but works at a hospital, such as radiologists, anesthesiologists, hospitalists, they will go to the hospital and ask for the employer, and they say, who's that? And then they go say, okay, we couldn't find the employer or the physician. The physician wasn't at work that day. So we want to go over all aspects of that if they plan to visit you. And they do give you notice for the visit. Great question. So the lawyers will tell you about the public access folder. Next question. Can a J-1 physician apply for a J-1 physician waiver and a hardship waiver? Great question. Only one federal interested government agency waiver or state 30 waiver may be pending at the same time. A physician is always required to submit an affidavit that they only have one pending. If it's denied or you withdraw it before it's approved, then you can apply for a waiver with a different employer and a different agency. You can have a J-1 physician waiver, either federal or state 30 pending, along with a hardship waiver or along with the persecution waiver. So one interested government agency waiver at a time. However, if you want to increase your odds and file hardship, persecution, and a state 30 waiver all at the same time, you may do so. However, with the caveat that you are required to accept the waiver which is approved by the State Department first. Okay, and that is the end of our questions. Is anybody, oh, one more.
Oh, yeah, you're good.
Somebody asked a question about a research-based HHS waiver. So HHS issues clinical care waivers, which is what we discussed. They also do research-based waivers. I would highly not recommend them for everyone. Number one, approval is uncertain. Two, they are now taking about 3 years of your life just to process them. And with an uncertain outcome, even though the physician may be a rocket scientist. So the nice thing about waivers is you generally know whether you're going to get one once the state or federal agency acts, and they usually act pretty quickly. One of the longest states is New York, and they don't usually announce the results till April. Next question. For institutions that have not done IGA waivers before, can they be successful for subspecialty recruitments? Absolutely, and it depends on the state. But yes, and certainly you don't have to have done one before to get the next one. Okay, and that's our last question. And I want to remind everybody that we will have this on our website and on YouTube. Is it within a week. And if you have any questions, put the address, email me at my email, Jan. You put my email in the chat box. It's also in the slides. That's my email, and I thank you. We also have the updated J-1 position pamphlet available, and just ask us for it. You go wcslaw.com, and you can request that, and you can subscribe to our updates on all things physician and J-1. And thank you all so much for attending. And I look forward to continuing to work with you. For those of you we're already working with, and to working with those of you who are new. Thanks again. Have a great day. Bye, everybody.